Hello everyone, welcome to my channel. So today we will understand about what is an intellectual property right and what are the various types of intellectual property rights that are available. So before we understand what is an intellectual property right, let's understand what is an intellectual property. So the meaning of the intellectual property is in the term itself. Okay, so it's a property of one's intellect. That is, anything that you create from your own intellect or your mind is referred to as intellectual property. Let's see some examples of intellectual property. Now, intellectual property might include inventions, literary works, artistic works, designs. Okay, inventions such as pen, mobile, laptop, watch, air conditioner. Now, these were certain products which were thought about by someone in order to solve a technical problem. And since they were thought about in someone's mind, they are referred to as intellectual property. The same goes for literary works such as books, stories, lyrics, poetry, speech. Someone who wrote a book thought about the book or thought about the idea in his mind first and then eventually published it and brought into reality. So that is also a type of intellectual property. The artistic works such as painting, songs, music, photos, again, someone thought about the song or maybe the image that they're going to capture. First they thought in their mind and then they eventually brought it into reality. So artistic works are also a type of an intellectual property. Then there are designs. Designs are basically the aesthetic appearance of a product. So if a chair looks unique, or the design of a bottle, or the design of a necklace, these were also thought by someone first and then brought into reality. And so design is also a type of an intellectual property that can be protected via the intellectual property rights. So those were the examples of intellectual properties. Now let's understand what is intellectual property right. So as per the definition, intellectual property right refers to the legal rights given to the creators of intellectual property to protect their creation for a certain period of time. Okay, so as per the definition, intellectual property right is something which is provided by the law to help the creators to protect their creation so that others might not be able to use it without their permission. Now you might wonder, why are intellectual property rights needed? Okay, so let me give this example to make it more clear. So imagine you face a problem. Okay, you come across a problem. Now you might think about a solution in order to solve that problem. Okay, you spend time, you spend effort on it, and in some cases you might even spend money to solve that problem. And after spending so much of time, effort, and money, you might come to a conclusion or you might reach a solution which helps in solving that problem. Now, if there were no intellectual property rights available, then anyone might use that solution without your permission and they might use it for their advantage. Okay, so this is a very major drawback for you because you have already spent so much of time, effort, and money, and you're not getting anything out of it. And someone who has not done any of those things are gaining the advantage from it. So just because that should not happen, the government of each country came up with the intellectual property rights. Okay. Now let's go one by one regarding the importance of intellectual property rights. So as I said, intellectual property rights provides protection to the rightful creator on their creation. So since no one can use your invention or your creation without your permission, you have the rightful protection on it. Second, it provides incentives to the creators for their creation. So you came up with this solution. Now you have an option to sell this solution. After you have, let's say, patented it, you can sell this solution or you can sell the patent itself. So in both ways, you are getting some kind of incentives. Then the third is to accord recognition to the creators for their creation. So for example, let's say today we see a song. Okay, so we can see who composed that song. Okay, and that is how that the composer of that song is getting the recognition. So intellectual property rights help in providing recognition to the creators for their creation. Then, as I said, since these intellectual properties which are created by the creators are protected, they can go and confidently create more intellectual properties, which in some way is directly, accelerating the technological industrial development of the countries. And then the last point, is as the intellectual property prevents others from, making a copy or creating the product without the permission of the actual creator, only we can, or the actual author can, actual creator can produce genuine and quality products, which will be available to the customers. Now let's see the different types of intellectual property rights that are available. So there are various types of intellectual property rights such as patent, trademark, copyright, design, geographical indication, and trade secret. So I'll be explaining about each one of this in more detail in the next slides. So let's start with patent. A patent is an exclusive right granted by the government to an owner of an invention for preventing others from making, using, selling, importing the invention without his or her permission. Okay, so there are basically two keywords. One is patent, and second is an invention. Now, what is an invention? Invention is a technical solution to a problem. It can be a product or a process which solves a problem. Now, such kind of an intellectual property can only be protected by patents. Okay. Uh, Second thing is a patent is granted for an invention and not an idea. Okay, so there is a difference. Now let me explain this through an example. So if I ask you, what is the fastest way of traveling from point A to point B, you might say flying. So if you see, flying is just an idea, but what is an invention? An invention is an airplane. So airplane is a product that can help you from reaching point B from point A in the fastest way possible. So airplane can be protected, but the mere idea of flying cannot be protected. So it's very important to understand this, that an invention can be protected by a patent, but an idea cannot be protected. Then the another very important point to understand is a patent is a territorial right. What that means is, if you want to protect an invention, then you need to protect that invention individually in the countries where you want to protect it. So there is nothing called, a global patent where you would expect, that you would file a single patent application and then you get protection for your invention in the entire world. So there is nothing like that. Patent right is a territorial right. So if today I want to protect an invention in India, in US and China, then I'll have to make sure that I file a patent application in each of these countries and follow, the patent process in each of these countries to get a patent grant. Then the last point related to patent is the lifetime of a patent. So a patent is valid for 20 years only. So if I file an invention today, and if eventually if it gets granted over a period of time, then I will have the rights over my patent for the next 20 years. Okay. After that, it falls in the public domain. What that means is anyone is free to use, once the patent falls in the public domain, and I will not have any right over it. So these were some important points with respect to the patent. Now let me just show you some examples of patents or patentable inventions. Now these are some examples. A mobile phone, which we are using in our daily life. It's a technical solution to a problem. Okay, it made the communication easier. In fact, a mobile in itself is includes thousands or even lakhs of patents. So each component or each feature, whether it's related to display or the volume button or the speaker or the apps, all of these things are protected via various different patent applications. And that is why a phone is, it's not just made of a single patent application, but it includes thousands or even lakhs of patent applications. The second example is car, again, a technical solution uh, to a problem. It has made the transportation easier. The car also, similar to phone, includes a lot of patents. So each component or each part of the car may have thousands of patents on it, whether it's the headlight, whether it's the windshield, whether it's car body, engine, you name it. Each of these components or these parts of a car are protected by multiple number of patents. Then a light bulb. So we all know light bulb, is one of the most earliest of inventions. A light bulb was invented by Thomas Edison. That was also patented. And even today, any improvement that is happening in the bulb or in the lighting systems is protected by patents. So these are some examples of inventions which can be protected by a patent. Now let's understand what is a trademark. So as per definition, a trademark is a logo, symbol, word or a phrase that identifies the source of your products and distinguishes them from the products of other competitors. Okay, now you would have seen a lot of trademarks. Okay, let me just give you an example of the M sign of McDonald's. Uh, Now whenever you see that M sign anywhere while you're driving on the highway, you know that there is a McDonald's somewhere close by. So what is that? That is a trademark by the McDonald's company, and that helps us to identify the products of the company, and it distinguishes them from the products of their competitors. Okay, now a trademark is valid for 10 years from the date of application, and it may be renewed for every 10 years on the payment of prescribed fees. So a trademark is such an intellectual property right that can keep going if you are, paying the payment amount or the required fees time to time, and you can keep it going indefinitely. Then trademark has different symbols used. So some of you might have seen a sign TM, on the right top corner of a logo or of a company name. So TM is used when the sign, when the trademark, when the logo that they have been using is not registered, but they're using it. So at that time, TM is used. And in case the trademark or that logo is registered by the, Patent and Trademark Office, then the R sign is used as shown here, and that represents that the trademark is registered. So these are the examples of some of the famous trademarks. Okay, I need not even mention the names, and the moment you see this logo, you will understand, which company it belongs to. So one is Tata, very famous. Tata is there in each and every field in India, I would say. Okay, then there is Google, Facebook, KFC, Apple, Mercedes, Starbucks, BMW. So these are all famous trademarks, and having a trademark registered, allows you or provides the right to you, and nobody else can use your trademark without taking permission from you. The next type of intellectual property is copyright. So copyright is a right granted to creators for their literary, musical, dramatic or artistic works. So as I mentioned in the initial slides, there are some types of intellectual properties which belongs to literary and artistic works. Okay. For example, a book, a photograph that is taken, or lyrics of a song. So these kind of intellectual properties are protected by copyright. Now, copyright comes into existence as soon as the work is created. So what that means is, whenever an author or a creator creates, a literary or artistic works, he or she need not even go to the patent office to register it. In fact, the moment from which they create that work, it is protected by the copyright. But still, it is recommended that you go and protect it, because that provides an additional protection, as well as in case if some situation happens where someone might copy your work. So having a copyright registered helps you in that kind of a scenario. Then the life of a copyright is the author's life plus 60 years. Okay, after a period of author's life plus 60 years, the work loses the copyright protection, and then anyone is free to use it. Then it is protected by a symbol C, which actually represents the copyright protection. And I'm sure many of you would have already seen this. So if you see maybe a novel or a book, you might see somewhere at the back the C symbol, and that shows that the work is copyright protected. So these are some examples of work that can be protected via copyright. A painting is an example of a work that can be protected via copyright. Photos can be protected by copyright. In fact, you would have seen those websites like Shutterstock. They have a lot of images for sale, and all those images are copyright protected. So in case you want to use those images, you will have to pay them certain amount, and then you are free to use it. But if you are using that without their permission, then they have the full authority to come and file a case law against you. Then music, for example, is an example of work that can be protected via copyright. A book can be protected via copyright. Then movies can also be protected via copyright. So if you are sharing movies without taking permission from the owner, then you are violating the copyright law, and they have the full authority to come and sue you for violating the copyright protection. Now, the next kind of intellectual property is design. So design basically refers to the visual appearance of a product or an object, including its shapes, configuration, pattern, ornamentation, and color, or a combination of these features. So when you see a product and it has a beautiful appearance, or a unique appearance that makes it distinct from other kind of products, then such kind of products or such kind of designs can be protected via the design protection. Okay, it is very important to understand here that design protection does not provide any functional protection. So if that certain product have a functional value, if its function is of some kind of importance, the design protection does not help in protecting that. It only provides protection to the appearance or the aesthetic value of that product. Now, design rights last for 10 years from the date of registration, with the possibility of renewable for another 5 years. So, the maximum protection a design can provide is 15 years to the product. Now, let's check some examples of products or objects that can be protected by design. So, one of the famous example is the Coca-Cola bottle. If you have seen the bottle, it has a unique shape, and that shape is protected via design registration. Then the shape of a chair, if it's unique, it can be protected via design registration. Then a shape of a necklace, or the pattern in a necklace, that can be also protected via design registration. And a helmet, so if the helmet has a unique design, that can be also protected via design. So if you see, the design does not protect any of the functional aspect of the product. It only provides the appearance or the aesthetic look of the product. The next kind of intellectual property is the geographical indication. Now, geographical indication is a very unique kind of an intellectual property. It's basically a name or a sign that is provided on a product, which corresponds to a specific geographical location or origin. So what it means is, if a certain product comes from a certain location and it has a specific characteristic because of, either growing or coming from that location, then it is eligible for a GI tag. Okay, I'll give you some examples. Let me just cover the second point. So GI identifies a product as originating from a particular place and having certain characteristics or qualities that are unique to that place. Now, let me explain this in more detail with an example. So let's see the example of Darjeeling tea. Now, Darjeeling tea is very famous for its taste. Okay, so have you ever wondered why is it so famous? It's because the tea leaves that are produced in Darjeeling, they develop certain characteristics because of that geography, which provides a unique taste to the tea that is eventually made with the help of those tea leaves. So now it's very important to keep the quality genuine, and that is why the GI or geographical indication came into existence. So as per the intellectual property right, the GI tag is provided only to those products which satisfies the condition of that specific geography. So that what that means is, let's say someone who is manufacturing tea leaves in Maharashtra. Now they cannot use the term or tag G of Darjeeling tea, because those tea leaves, even though it might taste somewhat like that, but eventually it would not have the same essence of a Darjeeling tea. So the tag of GI helps the consumers or the customers to identify the genuinity of the product. So there are various examples like that. For example, Alfonso mango. Alfonso mango, also known as Hafus, they come from a certain region of Maharashtra, and because they are grown in that region, they have a very sweet taste, and that taste cannot be produced in mangoes coming from other regions. And that is why the tag of Alfonso mango, GI of Alfonso mango, can be used by only those companies, or those this manufacturers, or the distributors who are bringing mangoes from that region of Maharashtra. The same goes for Banarasi sari. Banarasi sari again has that effect, and the saris which come from Banaras can only use the GI tag of Banarasi sari. Then the example is of Kashmiri saffron. So the saffron that come from Kashmir are very popular, and only those saffrons which are produced in Kashmir can use the GI tag of Kashmiri saffron. The other companies or the manufacturers cannot use the GI tag of Kashmir saffron unless and until they produce saffron in Kashmir. So this is the last intellectual property right which is presented in this slide, and that is trade secret. Now trade secret is again a very unique kind of intellectual property, because in case of trade secret, it is not registered in the intellectual property office. A trade secret is basically a confidential information that gives a company a competitive advantage. So one of the very famous examples of trade secret is the ingredient of Coca-Cola soft drink. Okay, so that ingredient is kept trade secret. That means the company has not gone to the IP office and disclosed it and protected it via any IP rights. It is just kept confidential. So unless and until they can keep it secret, they can keep producing and have the competitive advantage over other soft drink owners. The same goes for KFC chicken. So the ingredient of preparing a KFC chicken is again kept trade secret. So no people can taste and maybe reverse engineer and create chicken which tastes similar to KFC, but then the actual taste of KFC ingredient is not known. It has been kept confidential. It has been kept trade secret. So trade secret can be any formula, pattern, compilation, program, device, method, technique, process, or the information that is not generally known or easily discovered by others. Examples of trade secret can include customer list, manufacturing process, recipe, marketing strategies. So these are all the examples of trade secrets, and the only way of protecting the trade secret is limiting the number of people or the parties who are aware about this information. Also, maybe the companies can sign a non-disclosure agreement with the parties involved, so that they might not go and leak this information or these trade secret to the outside world. So this is a kind of intellectual property which is kept secret for indefinite amount of time until the company can protect it. So these were the different intellectual property types, and how which protects different kinds of intellectual properties. I hope this has made it clear for you about what is intellectual property and what are the types of intellectual property rights that protects different kinds of intellectual property. So in the next presentations, we will learn more about the intellectual property types and go further deeper into it. So thank you all for your time.